discuss the freedom to assemble peaceably and without arms as provided you Article 19(1) of the Constitution. What are the limitations on this freedom? Ans. Freedom of assembly. Article 19(1)(b) guarantees to all citizens of India right to assemble peaceably and without arms. The right of assembly includes the right to hold meetings and to take out processions. This right is, however, subject to the following restrictions. 1. The assembly must be peaceable. 2. It must be unarmed. 3. Reasonable restrictions can be imposed under Clause 3 of Article 19. The right of assembly is implied in the very idea of the democratic government. The right of assembly thus includes right to hold meetings and to take out processions. This right, like other individual rights, is not absolute but restrictive. The assembly must be non-violent and must not cause any breach of public peace. If the assembly is disorderly or riotous, then it is not protected under Article 19(1)(b), and reasonable restrictions may be imposed under Clause 3 of Article 19 in the interest of sovereignty and integrity of India or public order. When a lawful assembly becomes unlawful. Article 19(1)(b) says existing Indian law regulating public meetings in the interest of public order if the restrictions are reasonable. If an assembly becomes unlawful, it can be dispersed. Chapter 8 of the Indian Penal Code lays down the conditions when an assembly becomes unlawful. Under Section 141 of the Indian Penal Code, as assembly of 5 or more persons becomes an unlawful assembly if the common object of the persons composing assembly is a. To resist the execution of any law or legal process. b. To commit any mischief or criminal trespass. c. Obtaining possession of any property by force. d. To compel a person to do what he is not legally bound to do or omit which he is legally entitled to do. e. To overawe the government by means of criminal force or show of criminal force or any public servant in the exercise of his lawful powers. An assembly which was not unlawful when assembled may subsequently become unlawful if it becomes violent or is likely to result in disturbance. Under Section 129 of the Criminal Procedure Code, 1973, such an assembly may be ordered to be dispersed if the disturbance to the public peace is reasonably apprehended. Section 151 of the Indian Penal Code makes it an offence not to disperse after a lawful command to disperse has been given. Section 107 of the Criminal Procedure Code empowers magistrate to obtain security for keeping the peace from any person who is likely to commit a breach of peace. Section 144, Criminal Procedure Code, 1973 empowers the magistrate to restrain an assembly, meeting or procession if there is a risk of obstruction, annoyance or injury to any person lawfully employed or danger to human life, health or safety or a disturbance of the public tranquility or a riot or any affray. In Kameshwar Prasad v. State of Bihar, AIR 1960 to SC 1166, it was observed that broadly stated a demonstration is a visible manifestation of the feelings or sentiments of an individual or a group. It is a communication of one's ideas to other to whom it is intended. There are forms of demonstration which would fall within the freedom guaranteed by Article 19(1)(a) and 19(1)(b). A violent and disorderly demonstration would not obviously be within Article 19(1)(a) or (b). but peaceful and orderly demonstration would fall within the freedoms guaranteed under these clauses.